Hello, this is Erick Widman from Passage Immigration Law. Greetings from Portland, Oregon. We're proud to have expanded our presence from Oregon down into California, where I'm originally from, and also up into Seattle, Washington. So we have 3 offices now, and we serve clients throughout the United States and the world. So that's one of the main reasons we love immigration law is we get to deal with people from all over the world. And that keeps it interesting, never a dull moment, that's for sure. So we have a number of really good questions again, and the first one we're going to start off with for our live immigration Q&A session. First question is, can a CBP officer keep me from entering the United States at the border? And the answer to that question is definitely yes. And I know this person was also wanting to ask if you could be removed from entering the United States and basically be given a removal order. And unfortunately, the answer is yes there too. And that's an expedited removal order. So in some cases, CBP officers can basically act like the judge, jury, and executioner and decide that you're inadmissible for entry into the United States, you're inadmissible, and you're going to be barred from re-entry if you get hit with an expedited removal order. So CBP officers do have that power, unfortunately, and they will fill out a document for you that says expedited removal order and usually has a series of dates up on the top of it that says you're prevented from coming back into the United States for 5 years or 20 years. And the consequences of this are not good. They're quite dire. And you would need a waiver to be able to get permission to come faster than what it says on that expedited removal order. So there's lots of power that the CBP officers have at the border. And the U.S. Supreme Court has constantly reaffirmed that they do have a huge amount of discretion and power at the border. And unfortunately, even the Fourth Amendment of the US Constitution does not apply at the border. So Fourth Amendment says there should be no unreasonable searches and seizures in general committed by the government. But that is allowed, essentially an unreasonable search or an unjustified search, where you don't have, for example, probable cause, that is allowed at the border. So the discretion of a CBP officer to go through your bags and even have you unlock your phone or laptop require you to do this and download your data, and they would simply pursue a phishing expedition. That's essentially what it is. They would download your information and translate it as needed into English and look for keywords of things they're looking for, whether it's immigrant intent or controlled substances, whatever it could be. They're going to be looking in that instance for all kinds of evidence for it. And you're not going to have much of a chance of keeping that out of court because the Fourth Amendment doesn't protect you like it does elsewhere in the US. So unfortunately, it is important to be well informed so you can prevent situations like this where the government gets power over your life. And we certainly want to arm you with knowledge and understanding and give you actionable principles here. Okay, so the second main question, how could I qualify for an EB-3 visa? So that's a pretty extensive question, actually. And of course, the facts of your case, your individual qualifications make all the difference. That's where the rubber meets the road. The facts and the law interact together. But here's some general information. And I recommend looking at the USCIS website as a great, reliable starting point for information about this. So it is the third preference employment-based visa category, EB-3, So EB1, EB2, EB3. And this category does require more work than many EB1 cases. There are more steps, at least. They're all a lot of work. But this labor certification requirement, where you show the U.S. Department of Labor that it is fine to hire you, that's one of the key requirements there. And there are three main subcategories that you could fall into in the EB3 realm: skilled workers, professionals, unskilled workers. So like I mentioned, the labor certification is needed in each of those categories. Also, you're going to need a job offer from an employer. In practice, what we've found at our law firm, if you have a good employer who's motivated, gives you a job offer, and wants to work with you through the EB3 process, that's the majority of the battle. You're in good shape if you have someone who's willing to put the time and money and invest in you as a good worker to get through all the various steps. We've seen multiple times that an employer might be interested, but they bail out midway through the process, or find out more about the commitment and simply don't proceed. So having an accurate understanding of what's required, which is beyond this quick Q&A, is important. Feel free to get in touch with our firm, though, for a call with our expert business immigration attorney, David, support@passage.law, or you can give us a call at our main line. All right. So next question. Can I petition for my aunt to come here into the U.S.? The reason is because she has to take care of me while I'm pregnant. Congratulations. And then take care of my baby eventually. What is the best visa option? All right. So you're initially asking, can I petition for my aunt? So the family-based immigration categories don't allow you to file directly for your aunt as if she were an immediate relative, which she's not. She's not a parent, she's not a spouse, and not a child. She's also not a sibling. So the main categories of family-based relationship don't apply to an aunt or uncle or a cousin. You can, however, help her get a visitor visa indirectly by, oftentimes we see people successfully file, and we encourage people to file an I-134 affidavit of support when your relative goes to apply for a visitor visa. So your aunt's going to have to apply for a B1, B2 visitor visa on her own. You also have to watch out for some work-related issues. Just consider it that if she's coming to work, or whether it's a question whether she is working for you or not. And if she's just going to help out around the house, like my own mother-in-law does when she comes to visit my wife. My mother-in-law and wife are from Hungary, and then she comes and stays with us oftentimes for half the year, and she uses a B1, B2 visitor visa. She's very helpful around the house, but it's not an employment relationship. She's not working here, but she's very helpful, as you could imagine. So be aware of the work issue, and you're going to have your aunt apply for a visitor visa on her own, but you can help support that application with that affidavit of support form I-134. Okay. And follow-up question, can she come with her husband? And if yes, what type of visa would it be? So the husband would also need a visitor visa. There's a good chance that, and we see this so often, so frustrating, there are just lots of denials issued for visitor visas. A lot of the considerations depend upon where she's applying from, what's her home country. But if a family is applying together, that's another reason why the visa might not be denied, because the consular officer suspects the family's going to be tempted to immigrate or is planning to immigrate. And so many people if they are married and mark that down correctly on the DS-160 form when they're applying for a visitor visa, if you mark down that you're married but your spouse is not traveling with you, that increases the likelihood, generally, that the visitor visa will get approved because the consular officer thinks you're not going to leave your family behind. You're going to return eventually to be with your spouse. But if your spouse and yourself are both applying for visitor visas, that can lead to a denial. Also, if you're ever tempted, which we've seen happen multiple times, to incorrectly, falsely state that you're married on the visitor visa application when you're not married, and you're hoping to increase your chance of getting a visitor visa, having that issued successfully because you say you're married and you'll be returning to your spouse, that has horrible consequences for you for the long term. That type of fraud could lead to a permanent bar for a future entry to the US. So, and that's the kind of thing that the government, you can assume, will be able to find out pretty easily. Therefore, always be truthful, not just because you're going to get caught, but because it's the right thing to do. But the government, you just don't want to give the government the ability to shut down your long-term plans. You want to keep flexibility open for where you want to live and where you want to be. And that's why the mission of our law firm is to live globally to help you and anyone achieve their full potential. Because oftentimes your full potential is going to be realized in the US, it's going to be realized in another country, like it was for me when I moved to Hungary. It was an amazing experience. I grew enormously when I lived as a permanent resident in Hungary for 2 years. Thanks for showing up. We appreciate your questions. Email us with further follow-up questions. We'd be happy to help. Give us a call and definitely take care. See you next week.